The name single-family court suggests a streamlined, centralized system, a one-stop shop designed to make the law easier to navigate. The court's reach is massive, processing everything from the division of assets in a standard divorce to high-stakes state interventions in sensitive childcare proceedings. Despite the name, the institution operates as a nested hierarchy, hidden beneath that unified label. Inside, you find overlapping layers of authority. It starts with volunteer lay magistrates at the base and moves through district judges, circuit judges, and high court judges, all performing different roles within the same administrative structure. This internal layering means that anyone looking to challenge a ruling has to navigate an invisible structure, where every step depends on the seniority of the person who just decided the case. You cannot appeal a family court decision simply because you disagree with the outcome. You have to prove the judge made a serious, objective mistake in the facts or in how they applied the law. There is also an immediate procedural bottleneck. You must explicitly secure a judge's permission before you can even file your paperwork. Once permission is granted, the standard window to file Form N-161 is a strict 21 days. But if the case involves an interim care order, where a child's living situation is at stake, that window collapses to just 7 days. Failing to clear these specific legal and temporal bars ends the appeal immediately, regardless of how strong the underlying argument might be. The logic of the system is dictated by a single variable, the rank of the judge who made the original decision. This logic is enforced by the Family Court Rules of 2014 and Schedule 10 of the Crime and Courts Act 2013, which act as the blueprints for the entire organization. Generally, a case moves up one rung. A decision by a magistrate or district judge is routed directly to a circuit judge. However, financial cases create a shortcut. If a district judge rules on money, the appeal bypasses the circuit level and goes straight to a high court judge. If the original decision came from a circuit judge, the case leaves the family court entirely, entering the high court family division. But for care orders, the case skips every intermediate tier and shoots straight to the Court of Appeal. Because of this rank-based system, the path of a case is often fragmented and nonlinear, despite the court's unified branding. Centralization was an intentional design. A gatekeeping team is supposed to assign the right judge from day one, theoretically keeping family matters in one dedicated system rather than scattering them across different courts. In practice, the system is routinely criticized for being incredibly lengthy and financially draining for the families caught in the gears. Even trained legal professionals frequently struggle to understand how these internal routes actually connect. We can see this frustration in the 2021 case of TK versus ML. The presiding judge issued a weary complaint, noting that lawyers still hold an ineradicable belief that cases requiring a high court judge must physically transfer to the actual high court, rather than utilizing the high court judges who already sit within the single-family court. The single-family court successfully centralized the administration of family law, but as the judiciary itself has noted, successfully challenging a decision